IIT Kharagpur. This topic is very close to my heart, and therefore it is always a great pleasure in discussing it, because I will be able to remove some of the confusions and generate some confusions. Now the topic is law of sedition from Droh to Desh. There are key drivers for today's discussion of for 50 minutes or 1 hour. First, we will try to theorize free speech, then the journey of sedition law, then this Droh and Droh will try to delineate what is it, a few important cases, comparative views, new law, and the way forward. Now, we all know that democracy can exist only if there is freedom of speech and expression. If there is limited or very much restricted or unreasonable free speech, then the democracy is just a sham. It is just for a namesake. Because democracy and free speech are two facets of one coin. It is the lifeblood, the oxygen for any democracy. That is why our constitution uses this term not just one time, but in the preamble we can find liberty of thought expression, which is also a pledge of every citizen that we will ensure it. Then Article 19(1)(a), freedom of speech and expression, which is provided to every citizen as a matter of right, and limitations on state, followed by Article 19(2), which has various restrictions, 8 restrictions. Other provisions of Article 19 are also a subset of freedom of speech and expression. Our member of parliaments and legislative assembly, they have special rights besides this fundamental right. They have special rights to free speech. And judiciary, they also have free speech, we all know, but probably this is the only constitution in the world which recognizes dissenting opinion in the constitution itself under Article 145. Dissenting opinion has been recognized in the constitution, dissenting by judiciary. Then papers get special rights, special protection under 361 capital A, and maybe if you go by interpretation, you will find many other provisions that deal with freedom of speech. Such an elaborate provisions of free speech is very difficult to find any other constitution. That indicates the concern of the framers of the constitution and the idea, the vision of one of the great architects of the constitution, Bharat Ratna Dr. Bhimrao Ambedkar. Now, this freedom of speech and expression, as I discussed with you, also comes with limitation. This is a part of fundamental right under Article 19(1)(a). At the international level, human rights document also recognize it. UDHR, ICCPR, they also recognize it. But every such recognition does come with limitation, restrictions. And in India, under Article 19(1)(a), there are not 1, 2, 3, 4, but 8 restrictions. Indeed, 1950 we had restrictions. The constitution came with restrictions on fundamental rights. 1951 we have increased, enhanced the restrictions on freedom of speech and expression. 1963, 16th Amendment, we further enhanced the restrictions. So many people probably do not know this trend, that in the very first 13-14 years, democracy also flourished, but at the same time, the restrictions also were increased. That indicates what was the approach of the first Prime Minister of India? Now, there are four categories of free speech. That free speech to individual, so we all can criticize each other, we all can speak in favor or against each other. You can agree with my views and I can agree with your views, and we can disagree mutually, we can dissent. But then there is a limit. We cannot abuse free speech. And if we abuse free speech, that is restricted under Article 19(2) in the name of decency or morality or defamation, for which Indian Penal Code Section 499 or new Penal Code, that is Bharatiya Nyaya Sanhita under 356, makes provision. Then I can support a community, write about a community, write against a community. I can write that Hindus initially in 1950s were not ready for reforms. They indeed were very much against the reformation process. So Hindu Code Bill in 1950s were opposed aggressively. We can say that Hindu, still they follow dowry. They need to change. So we can criticize Hindu communities for being patriarchal. I can criticize Muslim community also, that while Hindu community has ultimately accepted all sorts of reforms, the Muslim community is very much adamant and unnecessarily conservative to age-old laws and not willing to reform. So I can criticize the community, be Hindu, be Muslim, but then again, I have a limit. That limit is provided by the Constitution of India. Under Article 92, again, you cannot defame. You cannot create hate against one religion or other religion. Because public order is one of the limits under Article 19(2). You cannot do something which creates reasonable apprehension of public order. IPC makes provisions for it under Section 153A, 153B, 295A. In the Bharatiya Nyaya Sanhita, it is respectively 196, 197, 299. Those who are not from law background, in 2023, the Parliament has passed 3 laws. Indian Penal Code has been changed into Bharatiya Nyaya Sanhita 2023, and it will be enforced from 1st of July 2024. So bracket shows the provisions under new law. The third category of free speech is regarding institution. Can I support an institution and can I criticize an institution? The answer is yes. I can appreciate the approach of the courts for the judgments they have delivered, and I can criticize the court also for the wrong judgments they have delivered. So this is available, and this is available not only in those cases where cases have been decided. This is available where the cases are yet to be decided. They are pending cases. On pending cases, I can criticize, and you can criticize, and anybody can criticize, subject to those who are the direct stakeholders. Can I criticize the Parliament? Yes, I can criticize the Parliament. I can say that Parliament has passed many laws without much discussion, and therefore Parliament is not doing its work. It seems like idle, wasting the money of the poor persons. They are not doing their job. They should be thrown out. I can say that Parliament, there are a number of persons who are having serious criminal cases against them. It seems that Parliament has become a den of criminals. Can I say? Yes, I can say legitimately. But then I have to know the limit. And if I violate the limit, what are the limits? One of the limits under the Constitution, under Article 92, is contempt of court. Then special laws have been passed, 1971 Contempt of Court Act. If I violate the limit when I'm criticizing the parliament or parliamentarians, if I cross the limit, if I unnecessarily be hateful, if I convey completely factually wrong messages about the parliamentarians, about the court, then special privileges will come and I will have to be answerable. That is the limit. Then comes the fourth category. First is individual, second is community, third is institution, and the fourth category. Can I criticize the state? The answer is 100% yes. What for the democracy is if I cannot criticize the state for its failure? Can I criticize the state that a number of poor people are moving here and there, they are not getting sufficient food, how lots of people are unemployed, state is a complete failure? Can I say? Yes, I can say. Can I write? Yes, I can write, and anybody can write, subject to some of the rules like civil servants cannot write. But I and you, they can easily write on Twitter, on Facebook, on news media, on news channels, in our journals. Can I declare the state that it could not discharge its obligation during COVID? Yes, I can write. And you can write. But then, is there any limit? Of course, there is a limit. And what is the limit? In the Constitution under Article 19(2), two express limits are there. And the limit is, I cannot speak something that challenges the very sovereignty and integrity of India. Bharat tere tukde honge, we cannot speak like this. State. Can I do something? Can I speak something which reasonably challenges the very security of a state? No, I cannot do. I cannot do. I am free speech, but not free speech to this extent that I start telling the state that okay, the state should be disintegrated, and Kashmir should be given to maybe somebody else, and the Khalistan should be made, and statements like we will make a new country. These statements are not permissible as a free speech. They are not at all fundamental rights. These type of cases, when we speak, when we criticize the state, but we cross the boundary, are known as sedition. No, so these are the four categories. Now, then what becomes sedition? Sedition is an expression against the state. But that does not mean every expression against the state. And we will see the definition, how the definition is very clear on that. So first, that it is an expression against the state, number one. Number two, it is of grave form, serious form, not casual type of statements against the state. Third is expression against the state which challenges the very authority of the state, which has the tendency of disorder or violence. So there may be four elements of sedition. One is, it is an expression against the state. Second is, this expression against the state must be grave and not casual. Third is, this expression against the state must create some tendency of violence or disorder. Underline the word tendency of violence and disorder. Not actual violence, not actual disorder, but tendency of violence and disorder. Why? Because for actual violence there are already laws. Sedition has been brought with this special purpose, that in certain cases violence may not take place, but there is only tendency of violence, the matter is serious enough where to try for it, so the sedition law is there. Now, if we see the journey of sedition law, in Britain, there were initially two types of laws that were against the state, directly against the state. One was treason, and then there were other offences. There was such category where somebody says something but does not resort to violence. So in those cases, treason was the only option. And during Henry VII, Tudor dynasty, a number of people were hanged in different manners, publicly hanged, uh, because they spoke something against the king, and whatever they spoke, they were indeed justified. So it was thought later on that in those cases where somebody has spoken against the king, but he has not supported violence, he has not uh, means he has not committed violence, treason is little unjustified. And other offences were different kind, because they wanted some activity. So treason wanted some. So treason was unjustified because it was unnecessarily harsh, and other offences required some activity. How to punish these type of offences? Therefore, the law of sedition came in. The law of sedition therefore became a speech crime. You speak against the king, and then it amounts to sedition. Now, this speech crime, if we take note of India, can have three types of classification that I have mentioned. Three types of classification with four means points in each. First is 1837. Lord Macaulay drafted an Indian Penal Code, and in that, a crime like sedition was incorporated in 1837. In 1860, Indian Penal Code was passed. The Indian Penal Code was first drafted in 1837. It took some time, some redrafting, and ultimately in 1860, IPC was passed, but sedition law was not there, though it was easily drafted. Third turning point was 1870. Within 10 years, an amendment was passed and sedition law was incorporated in the form of section 124 capital A of IPC. 124 capital A of IPC, that is sedition law. But then sedition word was not used in 1870. Then in 1898, another amendment was brought in by the British because of some of the judgments. 1891, Bangobasi case came in. Then a few other cases came in. So in order to address those cases, in 1898, IPC was again amended and 124A was amended, and the word sedition was incorporated and other words were incorporated. I'm not going in detail of those words, but contempt, disaffection, and hatefulness. Three words were used. One of them were already there in 1870. Two of them were added in 1898. Another turning point, I'm not going in many other cases. For example, 1898, Lokman Tilak was convicted. He was again convicted in 1908, again convicted in 1918. Three times Tilak was convicted. Dr. Hedgewar was convicted in 1921. People do not know that the head of the RSS was also convicted under sedition law prior to Mahatma Gandhi. Mahatma Gandhi was convicted for sedition law in 1922. So another turning point was 1950, when we established our republic, our constitution. So the framing of constitution was going on, and when the draft constitution was presented, under freedom of speech and expression, Dr. Ambedkar proposed sedition as one of the restrictions out of many restrictions. This was opposed by Munshi, and ultimately sedition as a restriction on free speech was dropped. Was another turning point because in 1952 a judgment of the Supreme Court came in, that is a Supreme Court constitution bench judgment. Many people do not know about this judgment. It is Bharti Press case decided by the Supreme Court. And this case was not directly on 124 capital A, but on other provisions which have some link with sedition law, that is expression against the state. So 1952, Bharti Press case, the constitution bench made the first declaration that how to interpret an expression. And 1952, a test was given by the Supreme Court. The test we often say is in toto test. What is this in toto test? In toto test means, suppose I have written a pamphlet, I have written an article, I have written a tweet, I have written a Facebook post, I have written a book. In that book, you cannot pick up one page, two page. You cannot take out of 10 paras only one para. You cannot take one word or two words from the tweet and declare that this is the statement against the state and then start prosecuting. No. In toto test says you have to read the whole paragraph, whole passage, whole post, whole tweet, whole book. And after reading the book, after listening to the whole speech, not just one paragraph, para of the speech, if you find that the speaker intended to create a type of disaffection, hatred, or contempt against the state, not against maybe just prime minister or chief minister or just minister, no, against the state, then in those cases only seditious laws can be prosecuted. Seditious laws can come in picture. 1952. This is in toto test. 1962 was another turning point because this was the first time when the law of sedition was challenged before the Supreme Court. So section 124A, capital A, the constitutional validity was challenged and decided in Kedarnath Singh versus the state of Bihar in 1962. And the constitution bench, 1952, Bharati Press was also a constitution bench. Constitution bench means 5 judges. 52 judge decision was unanimous. All judges agreed. 1962 was all judges agreed. What did they decide in 1962 about 124 capital A? Number one, they decided that sedition law is constitutional. This is first point. That the sedition law is not unconstitutional. It is constitutional, but with a caveat. And what was the caveat? The caveat was that sedition law is constitutional, valid, only if the expression made has a tendency of violence or disorder. So I speak something and it is peaceful, it is not creating tendency of violence or disorder, then it cannot be treated as sedition. So what is sedition? That I speak something, it may be harsh in nature, and it must create a tendency of violence or tendency of disorder. Again, I would like to reiterate and remind, when I say tendency of violence, does not mean actual violence is required. No, actual violence is not required. Do remember why sedition law came? Because for actual violence already there was a law. Sedition law came to curb the inchoate form of this crime, that in the primary stage we can indeed check this pernicious tendency of sedition, separatist tendencies, speeches against separatist tendencies, without any violence, without any or disorder, it can be checked. So 1962 said that his law is constitutional only if there is a tendency of violence and disorder or disorder. Then in 95, this law was further checked by the Supreme Court, and the name of the case was Balwant Singh versus Punjab. In that case, the court held that if someone has made casual slogans against country, खालिस्तान जिंदाबाद, राज करेगा खालसा, हिंदू को तुम्हें देश छोड़ के जाना पड़ेगा, अब तो अलग से खालिस्तान बनेगा, these slogans are certainly very dangerous slogans. These slogans are certainly not permissible under free speech, not part of fundamental right at all. But if the nature of the slogan is casual, if the speaker is something which does not have influence over public, if the public does not take care of these odd slogans, then even if the slogan is anti-Indian slogan, it cannot be a part of section 124 capital A. It cannot be seditious. You can take other action, like maybe departmental action can be taken, like maybe action under CRPC can be taken where for good conduct, security for good conduct is given under section 108 of CRPC. This can be done, but this cannot be prosecuted under 124A. So 1950, the constitution came in, but the sedition as a restriction was not approved. 1952, RC Press case suggested that you cannot pick up just one sentence or two sentences and declare it is seditious. No, you cannot do like this. You have to read the whole paragraph, whole passage, and then find whether it is really seditious or not. 1962, the court further restricted it, and the Supreme Court said that there must be tendency of violence and disorder. And 1995, the court said if somebody is making casual slogans which nobody takes care of, if the speaker is having no influence on public, then it is not seditious at all. But kindly note, 1995 law, that is Balwant Singh, does not legitimize anti-India slogans which are serious in nature, which are spoken by someone who has influence, like some student leader is speaking in a famous university, Bharat tere tukde honge, and then other party is telling Inshallah, Inshallah. No, they are the serious slogans. They were indeed deliberate slogans. So deliberate slogans are not legitimized, but if casual slogans like someone who is maybe first time offender has maybe done something, has unfurled Pakistani flag and said Pakistan Jindabad, Hindustan Murdabad, that does not become per se seditious. Some other action can be taken, but not sedition law, because the boy is maybe 15 years or 12 years or maybe 18 years or maybe 22 years. He was just influenced by some leader, some YouTube post, so he was little radicalized. Sedition law is not for him. Sedition law is for those people who are indeed who intentionally do, who have influence, who can influence the society. Sedition law is for them. 2016 was a turning point in the sense that after around 20 years, people approached the Supreme Court that sedition law is being misused, and certainly it was misused. On the drop of the hat, the states, almost in all states, right from Kerala, Karnataka, UP, Bihar, Jharkhand to Delhi, many places, sedition law was abused and misused like anything. So someone approaches in the Supreme Court that please issue some directions. Well, Supreme Court said no directions required. Kedarnath Singh judgment 1962 is a perfect judgment, we have to follow it. Then in 2022, another case came. 2016 case was common cause case. 2022, another case came in, and that case was Wombadkar case. In Wombadkar case, the Supreme Court has ordered a virtual stay that no, sedition law has some problem, and therefore there is a type of stay on law of sedition 124 capital A. Why I am telling type of? Because there is a misinformation that there is a complete stay, absolute stay on FIR on section 124A, which is not correct. If you read the small order, they clearly says that FIR should not be registered, but in case if it is registered, then remedy can be taken. That means the court thinks that in some cases FIR can be registered, and generally it has not to be registered, but exceptionally FIR can be registered in suitable cases where some hardcore person is there, some seditious person is there, some separatist is there, and is bent upon to make speeches against our country. Then the law cannot sit like duck. So 22 was a development. In 23, another development came in the form of a law commission report. Prior to that, between 16 and 18, I consider a big development when Indian Law Institute, where I belong proudly, published a book on law of sedition and freedom of expression. And that is the exclusive book that has done comprehensive research on various aspects of law of sedition. The book reached to the conclusion that sedition law cannot be removed because of many circumstances. Of course, it has to be amended, it has to be reformed so that abuse can be addressed. In 2023, Law Commission of India started deliberating on sedition law. And I am proud to share that the Law Commission of India has requested this speaker to come, and the Law Commission members, around 7-8 members, they discussed with me for around 4-5 hours on various issues. Why this type of recommendation has been made by me, why sedition law is required, why should not we remove it, if the United Kingdom has removed, why cannot we remove it, what are your opinions? So I have given them my opinion, my views, and they wanted that what are the 2-3 suggestions you make. So I said that the way I have suggested in the book, that number one, the law of sedition should include mens rea element. Mens rea element means something that you do deliberately. So currently the law does not talk about mens rea element, so it should be incorporated. Law Commission of India did not agree on that, but I am happy to say that in 2024, when the new enactment came in, the enactment incorporated mens rea element. So we suggested that the law should be retained, and law is still retained by the Law Commission of India and by 2023 Bharatiya Nyaya Sanhita. And the Law Commission did not agree that the mens rea element should be incorporated, which I suggested. But then the new law in 2023 has incorporated mens rea element. Now, when we talk about expression against state and sedition, kindly note that sedition law is not limited to just 124 capital A. And I have cited you this through this PPT. A number of laws are there. Some of them, maybe 2 of them have been repealed. But then many other laws are still existing that punishes expression against the state. So, section 124A, CRPC 95, 108, 196, Unlawful Activities Prevention Act, Criminal Law Amendment Act 1961, a number of laws are there which penalizes expression against the state, and therefore they are a type of sedition law themselves. What is the current definition of sedition law under IPC? This is the definition, and if you read the definition in 1 minute, those in the field of law, I have a question that you can think and maybe later on answer. Whether it is a strict liability crime, you can see the definition. You can get a screenshot also for further discussion. And please let me know when you start discussing after 15 minutes, whether it is a strict liability crime or not. Please let me know. There are 3 explanations attached to this law. First explanation says that disaffection includes disloyalty. Disloyalty to whom? Disloyalty to the government? No. Why should I be disloyal to why should I be loyal to a government? I should be loyal to this country only. That is enough. I should be loyal to the rule of law. I should be loyal to the laws which are enforced, good or bad. Of course, I can protest against the law, but till the law is, I have to be loyal to the law. I need not be loyal to one party or one minister or one prime minister or one chief minister. Indeed, I can be against that chief minister or prime minister because I don't like him. So when we say disaffection includes disloyalty, disloyalty against country and disloyalty against rule of law. Disloyalty which challenges the very existence of the country, and not disloyalty to prime minister or chief minister or some minister or maybe president or maybe Supreme Court. No. Second and third are very significant. And second and third, if you read carefully, you will find that way back in 1898 itself, not in 1870, because these explanations were not there in 1870, 1898. The British themselves have permitted that you can have comments expressing disapprobation. You can criticize the measures of the government, but your purpose must be to bring some alteration through lawful process. So we can understand that current law itself does not criticizes, does not penalizes criticism against the government. No, it does not. Explanation 2 and 3 is very clear. And the law enforcement machinery, probably the police officers and sometimes the courts also, they do not read explanation 2 and explanation 3. It clearly says, and at least we should understand today, it clearly says that comments can be expressed which can be disapprobation, which can be dissent, which can be disagreement against the government's measures of the government. I may not agree on one policy of the government, and they will say, no, this is a bad policy. Maybe demonetization was not a good policy. Many people will say. The Supreme Court has agreed that no, it is okay, all right. This policy, we cannot go into it. So I can disagree with the government. So sedition law itself says that I can criticize the government. It is not punishable at all. See, it is written, do not constitute an offense under this section. Not at one place, but explanation 3. Do not constitute an offense under this section. So law officers, police officers, sometimes the courts probably do not read it, and the intellectuals also ignore it, and then they say that sedition law is a bad law. Sedition law themselves is not bad. It provides sufficient protection in the law itself as well as through court judgments. That is one reason why we suggested that we need to retain it, and there is hardly any serious problem with the law of sedition. Now we can make some analysis which I have already done, that it is an expression. I can speak, I can write, I can sign, visible representation, I can tweet. Why? When I speak something to bring hatred, contempt or disaffection or attempt also, not only this, but if I do attempt it, hatred, not speaking. See, criticism is not problematic. If I start creating hate against the government through wrong means, through something which is not factual in nature, or if I do something which is contemptuous to the government, which is creating disaffection to the government established by law. When I say government established by law, when the law says government established by law, does not mean the government in the Bihar, UP or West Bengal. No. Can I criticize the Prime Minister? Of course we can criticize the Prime Minister. Can I say I do not like this Prime Minister or the Chief Minister of West Bengal? Yes, I can say. When I say government established by law, does not mean the government which is working. Government means that when my expression is against the state. Thank you for some comments. I will discuss with those comments. Do write the comment again. Thank you. So when I say government established by law in India, does not mean the ministers. Ministers are not government. Government here means after democracy, 1950, the meaning of government has changed. It does not mean someone only in power. When he represents the state, and when something is challenged against the state, not just one government or two governments, If I say the chief minister has done this thing, if I have made some memes of the chief minister that happened in West Bengal, then sedition law was imposed and person was arrested. No, that is not like that. There are other laws for that purpose, and for this reason, we need not. For this reason, I would say that other laws can be used, but not sedition law. Other laws means Section 108 of CRPC is already there. Why don't you use it? But not like so. If I create hatred against the state, create contemptuous thing against the state, disaffection against the state, not just one government, then this is sedition. We will see that the new law has taken note of this, that the government established by law in India has been changed. That is very good development. Now, I already discussed with you the three explanations. I discussed with you loyalty, disloyalty against the state, not to the government. I can be disloyal to the government. So I have already discussed with these things. I am not in the case I had discussed with you, Shalwala Devi. I have already discussed. I am not touching upon Ramjilal Modi, Ram Manohar Lohia, but I would discuss Babulal Parathe case of 1961. In Babulal Parathe case in 1961, the Supreme Court has clearly held that clear and present danger test of USA is not applicable in India. So the freedom which is available in USA is not available in India. And we cannot import the doctrine of USA in India. That we need to understand whenever we say that USA में ये freedom है, USA में वो freedom है. We have seen what type of freedom is there in USA in last maybe 15 days. What happened in Colombia? Kedarnath Singh case I have already discussed with you. Balwant Singh I have already discussed with you. In Vinod Dua case in 2021, the Supreme Court held that if a journalist has written something on YouTube and it may be a great criticism, you may not like, it may be little harsh also, but if it does not create tendency of violence or disorder, the person cannot be prosecuted, and the case was quashed against Vinod Dua. And then 23 Development of Law Commission of India and Bharatiya Nyaya Sanhita, I have already dealt with. In 2-3 minutes, I will discuss with you the comparative jurisdiction, which is always a matter of curiosity. That UK has removed the law of sedition, that New Zealand has removed the law of sedition, that Australia has removed the law of sedition, and then USA had freedom of speech and expression, which is quite broad. To begin with the last one, I have told you USA policy cannot be a policy for India because of various reasons. The Constituent Assembly has rejected the USA policy because USA has an absolutist model, because there is no express restriction. Restrictions have come through Supreme Court judgment. So clear and present danger test is not applicable. Moreover, USA have various laws which still deal with seditious tendencies. Australia has not removed sedition, it has only removed the words of sedition. Of course, it has made some changes that current law in Bharatiya Nyaya Sanhita has also made. UK and New Zealand had certainly removed sedition law, but we need to understand. In the UK, the law was removed in 2009. The recommendation to remove law of sedition was made way back in 1977. 1977, the Law Commission of UK has suggested removing it, but the UK has not removed it. 1987, 1992, 1997, UK has not removed. 2005, the UK has not removed. You know the reason why? The reason was Irish Republican Army, which was a threat to the integration of UK. And UK has not removed the law despite the Law Commission recommendation. When in 2005, Irish Republican Army has clearly said that whatever we will do with the help of non-violent movement. We will not use arms, we will not use violence, we will not use disorder. Then the UK has removed this law of sedition 2009. So dear friend, when we suggest that UK has removed the law, we should be very careful that UK has removed the law only when the seditious and the separatist tendency have surrendered and the law commission has suggested that this law has to be removed. So we can see in India, law commission has never recommended the repeal of sedition law, and India, seditious and separatist tendencies have not gone. See, we can see what is happening regarding Khalistan in India or maybe outside country like Canada. So we cannot take these type of cases as non-serious cases. Now this is the current law, and in the next 5 minutes I will finish this current law, and then we will move to the question. Bharatiya Nyaya Sanhita has removed the word sedition, there is no doubt, but the spirit is incorporated under section 152, that the expression which challenges the unity, integrity and sovereignty of country still remains penalized since then. Though it is also punishable. Under UAPA it is punishable. But in UAPA maybe some action is required. In this case, action is not required. It is a speech crime, pure speech crime. It says, whoever purposely or knowingly, you can see the mens rea element has been incorporated. In the section 124 capital A, mens rea element was not incorporated. Mens rea element means you do something deliberately. So because this element was not there, law was likely to be misused. So even if someone maybe has said something without any intention, then the police was able to register a case, and sometimes the person has to go to jail also. So this is very good development, that it says that whoever speaks something with purpose or knowingly does something. So you speak something, sign, visible representation. Thank you again, I will come to that. Then it has added electronic communication, that I speak through electronic communication, and this has become order of the day. Every day we see electronic communication, we write sometime. This is the electronic communication going on between me and you, and some of you are posting, that is electronic communication. So it is good that electronic communication word has been expressly incorporated. Even if it was not incorporated, it could have easily been covered under the word otherwise. But for a greater clarity, electronic communication word has been incorporated. Another word which was incorporated, by use of financial means. So you do not speak something, but you financially support these people. Somebody is calling that Kashmir should be, India should be broken and Khalistan should be given to someone, and I have deliberately given them financial support. That is now seditious. 152 comes in picture. Now another thing is someone who excites or attempts to excite. So the offense, complete offense, as well as the inchoate form of offense, that is attempt to excite. If you excite or attempt to excite, cessation. If you excite, you may not do anything, but you excite someone. Okay, why don't you go and demand for Khalistan? This is an excitement. This excitement is not permissible, even if it looks like peaceful. No, it is not permissible. Cessation. Or if you are exciting armed rebellion, you are someone from maybe other country suggests that army should rebel against the government. That is sedition. That even if army does not do anything, because they are greatly faithful, we are obliged to army. So armed rebellion is also a part of sedition law, this new sedition law. Third is subversive activities. Activities which are inimical to the integration of country. When we say subversive activity, that does not mean any type of activity. Can I be subversive against the government? Yes, I can. I can have an anti-government activity. I can go and maybe call for a chakka jam and do something. Some other law will come in picture. But if I am doing some anti-government activity is not anti-national activity always, unless you challenge the very authority of the government, very authority of the state. So subversive activities. So in maybe indirectly, you are doing something which goes against the integrity sovereignty, security of this country. So those type of subversive activities are also punishable. Or you encourage feeling of separatist activity. It broadens it. So you need not to encourage separatist activities by suggesting them something. So if you are making these type of thing, the law will take care of you. See, so far as integrity of country is concerned, there is zero tolerance. And this sentence suggests no encouraging feeling for separatist activities because India has paid a great price for because of these separatist tendencies, separatist activities. Because we encourage such feeling, we lost two prime ministers, we lost chief ministers, we lost police officers, we lost judges, we lost around 50,000 innocent persons and army personnel in India. Where in country without war we have lost, a country has lost these type of people? Nowhere in world it has happened. So UK has not lost two prime ministers. US not lost two prime ministers. Australia has not lost two prime ministers. We have lost. We should be very careful. Therefore, these type of tendencies, any encouragement and feeling to separatist activities need to be nipped in the bud, and therefore this provision is very good. Then encourages something against sovereignty and integrity of India. Any encouragement and indulges in it or does some act. So this thing is punishable now. Now the minimum punishment in the previous law was fine only, which many people do not know. Fine was the only punishment also, but now the fine is been removed. So fine has become so it is the punishment has become little harsher. Punishment is now one form of punishment is up to 7 years. That means uh, maybe up to 7 years punishment can be given. So 1 day punishment can be given, 2 month punishment, 7 month punishment, 7 years punishment can be given. Earlier, after 3 years, there was only life imprisonment. So if you want to give someone 5 years punishment, you could not have given. Now you can give up to 7 years punishment. That is the advantage with this law. Explanation is very clear, and I think this is probably the last slide from my side, and then I will move to the discussion with you all. Explanation clearly says comments expressing disapprobation of the measures of the administrative or other action of the government with a view to obtain their alteration by lawful means without exciting or attempting to excite activities referred to in this section do not constitute an offense under this section. So this is only copy paste of explanation 2 and 3 of section 124A, that can you comment expressing disapprobation, can you criticize, can you dissent with the government, can you disagree with the government? 100%. The comment explanation makes it very clear. But you have to use lawful means. You cannot use unlawful means for this purpose. If you use unlawful means and it is against the state, it encourages separatist tendencies, if it encourages seditious tendencies, if it goes against the interest of the country, then you will be challenged. You see, the provision was earlier, the provision was against the government of India, that is Droh. You cannot go against the against the Rajya. You cannot go against the government. This has been removed. Now you may go against the government, which was already interpreted by the courts. It has been removed. So from Droh, now it has become Desh Droh, because against the government you can speak, but you cannot speak. You cannot do something which is secessionist. You cannot do something like armed rebellion. You cannot do subversive activities, which is something which endangers sovereignty and unity of integrity of India. So you can go against the government. So Droh is now removed and Desh Droh comes in picture. So that is how the transformation from Droh to Desh Droh. This is the last slide from my side. Just to recap, to have a recap, that freedom of speech and expression is oxygen for democracy. So dissent, disagreement is very, very essential for any democracy, and therefore our constitution protects our fundamental rights in the form of freedom of speech and expression, and this is given to member of parliaments. Our preamble also acknowledges it, and it comes with various limitations. 8 limitations are there. USA do not have any limitation in the form of in the constitution, but through Supreme Court judgment, USA has also brought in various limitations, various restrictions. Now, uh, sedition law has gone to many transformations. It was brought in 1870, 1898 amendments took place. Then 1962, first judgment on constitutionality came in Kedarnath Singh case, which said that there has to be a tendency of violence and disorder. Then 1995 says that casual slogans cannot be seditious. It may be prosecuted under laws, or maybe other laws can come in picture. Then in 2022, in Wombadkar case, there is a virtual stay on law of sedition. 2023, the recommendation of ILI as well as the Law Commission of India to retain law of sedition is is upheld, is incorporated in the new law, that is Bharati Nyaya Sanhita under section 152, and mens rea element has been incorporated. And now the Droh has shifted to Desh Droh because the government established by law, this word is removed. Not only this, the first explanation you can see, the first explanation you can see that disaffection includes disloyalty. This word has also been removed, as I told you, and as we have written in our book also. Why should I be loyal to a government? I may not be completely disloyal to the government, but I should be loyal to the country. This word has also been removed, and then government established by law India. This word is also removed. This is also how the shift from the Rajdroh and Deshdroh takes place. My phone number is there. I also include some of my lectures on the YouTube channel Anurag Deep ILI. On sedition law, there are at least 3 lectures. There are lectures on various other themes. You can join. Thank you very much. Thank you, IIT Kharagpur and the team and my friends at IIT Kharagpur. I invite the questions. Thank you again.
Thank you so much for this wonderful lecture, sir. There have been few questions. Should I read those questions, or you can?
Yes, you read the question so that others who are not able to see somehow the chat box can.
Yes, sir. So one question is from Swati Mohapatra. The interpretation of the words of the provisions are very clear, but at the end of the day, it is up to the interpretation of enforcement authorities, and they will interpret it according to their whims and fancies. How to put check on at a very initial stage.
Okay, thank you. Before that, there is another question from Sagar Biswas. What is about Vara Vara Rao? Why he is in jail? So I will begin with the first question. See, Vara Vara Rao is not only prosecuted under section 124 capital A of IPC. This is first important point that we should know. Against Vara Vara Rao and many others who describe them as human rights activists, there are very, very serious charges under Unlawful Activities Prevention Act. The charges are not that they spoke against the government. The charges are that they did not only spoke against the government, they did a lot of things which challenges not the authority of the state, but had direct link with sovereignty, integrity of our country. So, Vara Vara Rao and others have approached the Supreme Court not one time, 2 times, 3 times, but many times. But the Supreme Court has found prima facie case against them. So, Vara Vara Rao case is not like he is a complete innocent. If we consider that he is a complete innocent, indeed, it is a great misnomer. He may be a human rights activist. He may have done some good job, good work for human rights for poor people. But there are many people who have done good job. They also stumble. They also commit great mistakes. and if they commit great mistakes and if we do not follow the law, law will always take care of them. And we have a Supreme Court which is very bold, very strong Supreme Court, and they, if the case is something which is just an abuse of law, they will certainly take care of this. We know how the sedition law has been given a virtual stay. Supreme Court has given a virtual stay, but the cases like Vara Vara Rao and others are very serious cases. I have gone through some of these cases, and I suggest whosoever is interested, please do not just read the newspaper, do not read online news media, also go through cases, and a good researcher should go the original sources, that is the judgment, part of the judgment, and they will know how serious the case is. There may be a position that after maybe 5 years, 7 years, 3 years, he may come maybe because of want of evidences, but that does not mean they have not committed anything. So I have a strong reservation on saying that why is he in jail? He is in jail because the law permits him to be in jail, and the judiciary has permitted him to continue in jail, and we should rely on the wisdom of the judiciary. I will welcome any supplementary of Sagar Biswas he or she can post here. Swati Mahapatra has raised a very important issue, that it is ultimately to the enforcement machinery and their interpretation. Completely agree. And therefore, now the law contains mens rea element which the previous law did not cover. You can see, I just go to this slide and you can see this. This slide, those in the field of law, they can see that law does not use as 124A, capital A, which will continue up to 30 of June, does not uses any word of mens rea, intention, knowledge, reason to believe, nothing. So what happens, this is here, and then, so what happened, that in ILI, in training program of police officers were going on, and various training program goes on every year, and of judges also. So I asked these police officers, said, do you feel that mens rea, that is a police officer should look for what is the intention of the person, whether he said in good faith? Then 80% of the police officers says that no, we will only go by word. And because intention and knowledge word is not used, it is a strict liability crime, and therefore we will not go why he said so. What was his intention? Whether he said something innocently. When I asked judges, 60% of the judges said that we cannot go into if it is not written, intention and knowledge is not written, we will not go into. Fact of the matter is that it is not a strict liability crime. It is a general liability crime, and courts have interpreted many times that intention and knowledge is a part of it. Unfortunately, up to 2023, various IPC was amended, but it was not incorporated, despite various suggestions by the Law Commission of India also in 1971 and 1997. So now, so what is the advantage? Advantage is that if you use the mens rea element, and I come to the current definition, this is the current definition, and you can see purposely and knowingly. So now police officer has one element to look into, that okay, I have to see whether he has done it purposely. So this is one check which is there. Second check is government established by law in India. So if the government established by law in India word is there, the police officer will think, oh my God, he has spoken against the minister. Bring him, put him in the jail. He has challenged the government. Now this word is also removed. So I think the chances of misuse is likely to be reduced. Third is disloyalty section is also removed. So so this can also be little helpful, but this is certainly helpful if there is a sensible person, if there is proper training of the police officer, that you have not to put the person, register a case under FIR or put the person in jail just because he has spoken something against the government. Please see whether he has really challenged the state, whether he is going against trying to do something or planning to do something, or having said something, he has said something which is against the sovereignty, integrity of the government. Again, has he resorted to some subversive activity? So the training of persons must take place. This is one. Secondly, the police officers should also be made aware of that besides 152 of Bharatiya Nyaya Sanhita or 124 capital A of IPC, there is already a provision under CRPC that deals with sedition law, that is 108 of CRPC, that says that you can need a security for good conduct, and it was incorporated in 1998. Why? So that those people who are not deliberately involved in this, then they should be dealt with not under 124 capital A, but under 108 of the RPC. Indeed, the Imperial Parliament of the Britain, when they were incorporating 108, and it was 108 of TRPC, it was asked that when 124A is already there, why are you incorporating 108 of TRPC? It was answered by British Parliament, answered in the British Parliament, that is Imperial Parliament, that it is for that 124A is for those people who do it deliberately, who are hardcore sadists, going against the government every day, and for first timer, those who are just supporters, we have 108. We have not we have not learned the spirit of this law in the independent country. So this is my answer, that of course this interpretation is on the enforcement machinery. Therefore, police should be trained that this is the current law. The law is changed now. Otherwise also we have a Supreme Court judgment. They should be trained that Supreme Court judgment Kedarnath Singh does like this, has already restricted the law. Ben Singh, but Malwan Singh has already restricted the law. This is one. Second is, the police officers should be made accountable also, that some accountability mechanism should be there. If they register FIR unnecessarily, some accountability mechanism under police law 1861 or other law should be brought in. So these are the two ways how to make them accountable. I am coming to the next question which I am able to see, and the next question is by Aniruddha Sarkar Datta. Uh, whether the concept of sedition, which derives the meaning from Rajdroh to Deshdroh, in course of time, is the key note in changing the name of our criminal law code from Indian Penal Code to Bharatiya Nyaya Sanhita? I think this is a philosophical question and good question. That we have changed the law. See, removal of the word sedition is one of the steps against decolonization. And removal of the words Indian Penal Code to a new word Bharatiya Nyaya Sanhita is also one step in the direction of decolonization. The word penal is replaced by Nyaya. That is a clear message to police, to judicial officers, and to prison officials that you are not there to penalize a person. You are there to give Nyaya. Nyaya not only to victim, but also to accused. Once the accused is in the jail, Nyaya is that he should be treated with dignity. Minimum lawful things should be made available to him. Fair trial has to be given to him. That is Nyaya for an accused. So this name change seems to be giving this message. But one should be very clear. Mere change of name will not change the system. We need to do a lot of things. We should not be in a confusion that Bharatiya Nyaya Sanhita or the two other laws is going to do miracles. At some time, people from non-law background feel. I am very clear on that. They are not going to change this Tariq for Tariq scheme unless we make radical changes. I am sure I can say that this is the right direction. Direction is very good, but this is not like that. It is a track where right track we have started moving the train, but train will not move like Shatabdi Express unless we make radical changes in IPC, CRPC, and evidences. Unless we use technology and unless we use ADR mechanism and unless we change the mindset of Indian who want to go for litigation for every other thing. Now, can you please send, okay, attendance sheet. Kindly fill. So, Sagar Biswas, I think, has a supplementary. Police is regarded as an authority who gives the charge sheet where it can be biased and wrongly acted. Why uniform police standard protocol for the whole country is not there in our country? What is opinion on this matter? Very good question. Very good question. Now, Sagarji, certainly police is the authority, not the first, not the authority. It is the first protector of human rights. Court comes later on. It is the second protector. Police is the first protector of human rights. So, first protector, first authorized protector of human rights. It gives charge sheet, there is no doubt. It can be biased, of course, it can be biased. It can be misinformed. It can be under pressure of the government. There is no doubt. Can they act wrongly? Yes, they can act wrongly. There is no doubt. That does not mean that charge sheets are generally biased or wrongly acted. There may be 10% such cases where the charge sheet is biased or wrongly acted. But to say that all the charge sheet is biased and wrongly acted, I think it is a little unfair assessment regarding the police. It may be negligent, but not biased, not intentional. That I understand, that I appreciate. So, if it is a biased and wrongly acted charge sheet, what is the next course? Next course is when the framing of charge comes in, the court hears the other party, and the charge sheet can be challenged before the charge is framed. Not only this, even if the charge is framed, one can go to the High Court to challenge the charge sheet, challenge the framing of the charges, and ultimately they can go to the Supreme Court for quashing those charge sheets. And charge sheets have been quashed. Charges were framed were quashed. So we have mechanism. Of course, the mechanism is slow. Why uniform police standard protocol for whole country is not there in our country? See, uniform protocol means the CRPC is one. Charge sheet is submitted under one provision of CRPC. In hybrid laws mean unlike UAPA, Unlawful Activities Prevention Act, Prevention of Corruption Act, maybe FOXO, these type of NDPS. Yes, there are special provisions of bail. There are special police, for example, in UAPA, NIA team work. But charge sheet is submitted as per law. What is provided under CRPC, so uniform provisions of charge sheet is there. Uniform format can be there. Of course, uniform format can be there. A uniform format can be made. It is not an easy task to make an uniform format. It is the researcher's business, ours and your business, to convey why a uniform format is required, why a uniform protocol is required, and what can be that protocol. It is our business, researcher's business, to suggest that there can be a uniform protocol. Then Vibhor Gupta, the question is, how can we have a system of integrating AI and academics with police station for guiding police and other criminal justice administrative authorities for correct interpretation of the statutory provision? I think a very good question. That AI and other modern tools should be integrated. I completely agree, but I think we are. This seems like a wishful thinking apparently for me. How many of us have gone to the police station? How many of us indeed have taken pain to register an FIR, inform the police on up to 13th May 2024? 5 months have gone. We see a brawl takes place. Two people are fighting. Have we ever called 112? How many of us have done? We do not call 112 or 100. We do not go to the police station. Whenever we go to the police station, see how the police is working. They work for 24 hours. We are talking about AI integration. Seems a very good thing. But let us do some more important thing. Prakash Singh judgment needs to be integrated first. The rule like maybe 8 hours or maybe 10 hours may be sufficient for police officers. They already have overburdened job. Have we ever visited our police station and found what is the sanctioned strength of the police and how many of them are working? One police officer. One police officer, there is working round the clock, maybe sometimes more than 24 hours. How many female police officers are there? So I think integration of AI with the police is a very good step, but I think more better steps are required to be done, like complete the sanction post, give them at most cutting edge infrastructure, them when they start treating police officers like normal human beings. Don't treat them like maybe they can be burdened for everything. They are being treated. They are being they are doing with the family disputes. They are not for family disputes. There should be other arrangements. So of course they should be trained. Integrating AI seems like very good. I would say again this is a matter of research work that we have to do. The government will not do. The law commission will do, or I will do, or you will do. That can we integrate AI and the police stations and then criminal justice system, interpretation of statutory provisions. Indeed, there is no need of interpretation of interpretation at the level of police station. Clear law should be made. This is the area you have to register FIR. You have not to register FIR. Even if to register FIR, why to arrest? Which law says you have to arrest the person? Arnesh Kumar says you need not to arrest if it is less than 7 years. Even if the more than 7 years, there is no urgency to arrest. Why do you arrest? Make them accountable for every such arrest, and then the things will start improving. And let us not try for arrest of the person that we do on Twitter and on media. Why that person of political party was, if I do not like our party, I will say Arvind Kejriwal should be immediately arrested. If I do not like BJP, we will say some BJP member should be immediately arrested. If I do not like Congress party, we will say some member of Congress party should be immediately arrested. At least the academicians should shun these tendencies of calling for arrest on social media. Stop this tendency. If we stop this tendency, then the things will start improving. Then Shivan Chattopadhyay. The question is, recently by amending UAPA 2019, government can accuse anyone as terrorist, which is completely wrong. It is not like that. Please read 2019 amendment. So, where lies the fundamental principles of freedom of speech and expression in here, which is enshrined in the Constitution? See, freedom of speech and expression in our country is very pious, and just because there are 1, 2, 3 illustrations of misuse, that does not mean the freedom of speech and expression is not here. Every day you go to the Twitter and Facebook, and please see how people write about the authorities. Obvious authorities means people call everything about West Bengal Chief Minister, everything about the Prime Minister, every abuses you can find. It is not that every time FIR is being registered. It is not like that. So 2019 amendment says that a person can be declared terrorist under certain norms. And what are the norms? The norms are there that a number of cases have been registered, that United Nations has declared. And see, gentle persons, this declaration of terrorist is not Indian phenomena. India has made it in 2019. United Nations declared people as terrorists. USA declared people as terrorists. UK declared people as terrorists. Australia declares people as terrorists. Canada declared people as terrorists without any type of trial. This is an administrative process. India has done it in 2019 because once a terrorist is maybe apprehended, or if a terrorist is not apprehended, his bank account is blocked. He started using other bank account in other name or other organization. So therefore, the person was declared terrorist. He has not arrested once he declared terrorist under 2019. His account is blocked, which is used for terror purposes, and then there is a surveillance measure. So it is a very good measure that is already required. Indeed, it is in line with zero tolerance approach against terrorism, which is also mandated by the United Nations. And there are sufficient mechanisms. If a person is declared terrorist, one can approach a tribunal is made, one can approach the High Court under 226, one can approach the Supreme Court under Article 32. Then Shiva Chattopadhyay,
Sir,
yes,
sorry to interrupt. We have another session to start.
okay,
We can take these questions tomorrow. Also, you have a session on
okay,
terrorism,
yes,
sir.
yes, yes. Thank you very much. You can have other questions. We can discuss these questions. Kindly secure these questions and pass to me if possible. Thank you again. To see you tomorrow. Thank you.
Thank you so much, sir. Thank you so much, sir.